G'day, I'm just here outside Tweed Heads local court, and I've appeared on a matter which was quite complicated due to the number of charges that were laid on our client and were presented before the court today. Going back to the very beginning, our client was charged with an incident where he was involved in a car accident. The police charged him with a drive under the influence of drugs, which is the most serious drug driving offence. It actually means that at the time of driving he was under the influence and impaired by a drug, namely cannabis, which was found in his blood at the time of driving. He was also charged with a low range drink driving offence of 0.052, very low reading but just over the limit. And because of the car crash, which did involve some injuries, it was quite nasty, there was a negligent driving charge which was laid. A negligent drive, stock standard neg drive charge with no death being caused and no grievous bodily harm being caused. So that was the first incident. Because our client does have such a poor history and prior similar offending on his record, the drive under the influence of drugs was the big issue for him, because it really did put him in the range of potentially serving full-time custody, especially given the aggravating features involving the car accident, the low-range drink drive, and the injuries that occurred from that incident. What we then decided to do is obviously take instructions from our client. He told us that he suffers from significant mental health issues, including bipolar, anxiety, and for a long time he has self-medicated using cannabis on a daily basis. But he did instruct us, and did even say to the police at the time of the charge, that he had not smoked cannabis for at least 24 hours, which goes to show, if he's honest in his instructions, that he would not have been impaired by cannabis at the time that the offence occurred. Certainly traces were found in his system, and that was done through the blood results which were taken at the hospital. But we decided to present the police with some written negotiations requesting that they drop the drive under the influence of drugs charge and reduce it down to drive with traces of drug in his system. We had to go and get a independent toxicologist report, whose report turned around and said that the level of cannabis found in his system would not have impaired a person who regularly smokes. And our client is a regular cannabis smoker, so over time a level of residual cannabis would build up in a person's system, and the level that was found in our client's blood is consistent with a person who regularly smokes on a daily basis, but not putting him into the range where he would have been impaired by cannabis at the time of driving. After many months of back and forth, the police decided to get their own independent toxicologist opinion. They decided to drop the charge of drive under the influence of drugs. So that was the big win for us. But that occurred in December 2020. It's now June 2022, and unfortunately over the last 12 months our client has been charged with 3 other separate charges of drive with an illicit drug in his system. See, his car has obviously been red flagged, and at any chance the police would pull him over to do a random test. And because he is such a regular cannabis smoker, on 3 other occasions he was charged with drive with a relevant drug present in his system, namely cannabis. So effectively before the court we had the first incident, which the drive under the influence of drugs was withdrawn, replaced with a drive with drug present, a low range drink drive, a negligent drive. And then we had 3 other charges on separate occasions with drive with drugs in his system. So he's obviously a habitual cannabis smoker, but he also drives as well. And he's quickly learnt that the two aren't conducive with one another. You just can't drive and be a regular cannabis smoker. So he's got to give up one of them. And that's his decision moving forward. He's going to have to make that personal choice. We because the matter was quite complicated due to the number of charges and number of events which occurred, we decided to put on some written submissions to the court to try and simplify each matter and provide a bit of a blueprint and a roadmap as to what each charge entailed, what the section was relating to the law, what the possible penalties were, and then we also outlined a number of submissions in those written submissions about our client's history, his mental health, his personal circumstances, the tumultuous upbringing he had, and obviously his attitude towards the offence. We also did propose suggested penalties in relation to the offences which were before the court. Now, the good thing about, for our client, was that none of these offences carried a maximum term of jail, so they were fine and disqualification of licence only offences. He was convicted on all charges. He was effectively given 6 months disqualification, which is the minimum for each of the drive with illicit drug present, except for one of them where there was a crash. He got 9 months for that. He got 3 months for the low range drink drive and a fine for the negligent drive. He also attracted fines for each of the offences, which did add up to probably in total around about $3,000 to $3,500. So he's going to be paying it off for some time. But the big win we had a couple of months ago was having the drug drive under the influence of drug withdrawn, because that took jail sentence out of the equation, and given his prior traffic record, he was in the range of receiving a full-time custodial sentence. So fine offences only. The highest period of disqualification he got today was 9 months. And all the other disqualification periods will run at the same time. So in 9 months' time, he'll be eligible to go back to the Transport Department and apply for a new licence, albeit with probably a 1-year interlock restriction on it. So yeah, very complicated matter. It's always good to sometimes put some of our submissions in writing to make it a little bit clearer for the magistrate to follow through. I got up and also gave oral submissions in brief format at the end, but the magistrate did give praise to the very good written submissions we put on, and he acceded to our requests in relation to proposed penalties. We had a very relieved client today. He thought he was going to be serving several years off the road, but we're able to convince the court otherwise. A very relieved client today. He's got a few problems to face in the future, but he needs to manage his way through that. But at least he's got a clear roadmap of how he can move forward from these offences and try and better himself as a person. So that's the matters here today at Tweed Heads Local Court. Thanks for tuning in. I want to thank you for tuning into Boorman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900. Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel, because we've always got fresh new content coming through all the time.